Appeal for hearing in the matter of Sexius versus the Attorney General of St. Lucia.
Good morning.
Morning,
If it may please you, my lords, David Dorset. I appear on behalf of the appellant. In this case with me is Mr. Andy George and Mr. Bala, my learned friend, Mr. Poole, on behalf of the respondent.
Thank you.
My lord, you should have an outline represented or speaking note. It just simply shows document entitled Outline of Appellant's Oral Argument, and which simply shows how we will be doing our oral presentation this morning.
Your route map.
Yes. Yes, my lord. And as your lords would know, this is an appeal where the appellant challenges the constitutionality of certain sections of the criminal code and certain rules as are found in the criminal procedure rules of St. Lucia. The effect of those impugned provisions is that the accused person is mandated to give a defense statement, and if the accused fails to do so, then adverse comment may be made with respect to this failure, and adverse inferences may be made against him at trial. The adverse inference being that he is guilty as charged. The core of the appellant's complaint is that the requirement to give a defense statement is a limitation on his constitutional right to silence, a right that is enshrined, embedded, and encapsulated in the Constitution. As you would see from the speaking note, the first point I would want to address is the preeminence of the Constitution.
Well, I rather doubt whether you need to stress that.
Well, if I may be just permitted just to show by means of a little analysis that I have done. If you look at the table, my lord.
Of course.
Yes, at the bottom.
Yes, I noticed that.
Yes, where we have basically done what we call a textual analysis, where we have looked at the number of times the words Constitution appears in our written case versus the number of times the word Convention or its abbreviation ECHR appears, both in our case and in the written case of the respondent. And you can see very, dramatically the difference. One.
Well, Dr. Dorset, I doubt whether the board's going to be impressed by the number of times you include a word in your case. It's the substance that matters. Yeah. And we do understand the importance of constitutions. We do sit as a constitutional court in many jurisdictions.
Very well. Well, I just thought I would make that point, particularly in light of what my learned friend says in his written case. And we think, we find this the greatest compliment, in particular at paragraph 15 of the appellant's written case, which is at page 163 of the record, paragraph 15, after he goes through what I call the preliminary matters.
Sorry, paragraph 15 of his case or of yours?
His case. Yes, the respondent's case. Yes. Paragraph 15.
Yes.
Where...
But you don't quarrel with that, do you?
Yes, well, that is the point that we are making.
Yeah.
So
it's common ground.
Yes, right. Yeah. Right, very well. Speaking on to the first subpoint, the protection of the law, your lord certainly would have had attention to section 1 of the Constitution, where reference is made to the protection of the law being a right to which all persons in St. Lucia are entitled to. And towards the end of that section, it indicates that the provisions of this chapter, being chapter 1, shall have the effect of, for the purpose of affording the protection of those rights and freedoms, subject to such limitations as are contained in those provisions. The protection of the law that springs from Section 1 of the Constitution is not exhausted by Section 8. Section 8 is a more detailed section of the Constitution, and our argument is that relying on the authorities of Matadine versus Putin, a Privy Council case, and...
Well, I think we know that that's very important, for example, in death penalty cases where the more detailed provisions of the later section are not sufficient, and protection of the law has been given a very wide interpretation, including covering right of access to international courts and tribunals, for example. Yes.
We would say that the right to silence is in the nature of an implied right to be found there, and we rely on the cases. Certainly, the dicta found in the case of Vincent versus the Queen, where mention is made by Your Lordships that the protection of the law provisions codify the common law to ensure that the person receives a fair trial, and that the Constitution is designed so that persons in the various jurisdictions receive no less favorable treatment that would arise from existing common law principles.
Do you want us to look at that
yes,
passage?
Certainly.
Vincent, tab 48.
Yes, Vincent, tab 48, my lord.
Unfortunately, in the bookmarks, we haven't the tab number, so could you give me the electronic bundle number, please?
1033.
1033, thank you.
So what are we looking at there? Which page?
It will be more in my case. No? 1038.
1038.
Thank my friend. Page 1038, at the bottom of the page, letter H. Letter H. The provisions of Section 20, which would be the equivalent to Section 8, do more than codify in writing the requirements of the common law, which ensure that an accused person receives a fair trial. And what our argument is that the Constitution of 1979 codified the common law as it was in 1979.
Well, that's a rather far-reaching argument, because concepts like fair trial can achieve significance which differs from time to time according to circumstances and according to changes in values and standards. And your argument would be an originalist argument. It would freeze the constitutional right to a fair trial in St. Lucia by reference to whatever happened to be the practices, which might, in fact, later be regarded as quite unfair, at the date when the Constitution was passed. So it's an argument which would cut both ways.
Well, my lord, if you look at the Court of Appeal judgment, certainly, the Court of Appeal judgment certainly recognized that in 1979 there was no thought or concept.
Yes, but that doesn't mean to say that we may not, over a period, acquire heightened understanding of what is involved in fair trial, or a different understanding. You can't say that the Constitution, by referring to a general phrase, using a general phrase like fair trial, freezes procedure.
No, no, not.
No, and it follows that there is room within the penumbra of whatever is from time to time regarded as a fair trial for changes.
Yes, my lord. No, with respect, I'm not saying or suggesting that procedure is to be frozen in time. Procedure needs to evolve to meet the requirements and to a certain extent requirements of the time. What my argument is that the right to silence was codified to an extent in the Constitution, and that right, once it is in the Constitution, cannot be limited by...
You're using the verb codified, but are you saying that in its condition at the time of the Constitution, the right to silence was, to borrow my Lord's phrase, frozen in time, and that it could not change in concept or content from the time of the passing of the Constitution?
More or less. That's the point.
Even though you accept the general proposition that my Lord has put to you, that the concept of a fair trial must inevitably alter with a greater insight into what a fair trial involves.
Yes, it can alter, but not to the extent of diminishing it. And what we respectfully submit.
Well, that's slightly circular because you have to analyse the change and ask, does this undermine the fairness of the trial?
Yes.
And merely because there's been a procedural change which might require a defendant to do something doesn't mean to say that the fair trial is unfair, even though previously the defendant wasn't required to do that.
Well, what we say that the changes that have come about as a result of these provisions that have been challenged, the argument has been made. It is procedural change. We respectfully submit that these are substantive changes, and we rely on the case of Murray. Murray.
What? Where is that?
Murray versus the DPP. And that is at tab 27, my Lord.
Thank you.
And this is a case that came to your lordships from Northern Ireland, where an order was made from which adverse inferences could be drawn. From silence.
From what?
Silence.
Well, from what kind of silence?
Well, silence. You know, if
it was from.
First,
it was. No, it wasn't. It was failure to give evidence, wasn't it?
Yes.
Yeah, but if you fail to give evidence and exercise your right to silence.
Yes, but forgive me, Dr. Dorset. You've got to focus on what it is that the provision which you're challenging says. The provision under consideration in Murray was the equivalent of what is now in England and Wales, Section 35 of the 1994 Act. It was a provision which allowed a court to draw an adverse inference from a defendant's decision not to give evidence himself at his trial. Now, first of all, do you agree that that's what Murray was about?
Yes, those were the specific facts.
All right, well, let's take it on from there. But, I mean, if we were in that territory, you'd have a quite different case, wouldn't you, because of Section 8(7) of the Constitution?
Yes, well, my Lord, to the extent that I am referring to this case, is just to highlight what has happened in terms of how certainly your lordships thought about the effect of a order or law, where the effect of it was that adverse inferences could be taken from an exercise of the right to silence.
Well, of one form of it.
Of one form, yes.
Yes, certainly.
And certainly as the Smith case...
I don't think you need worry, you know, that those of us who've had anything to do with current criminal law in this country are anything less than conscious of what's happened to the right to silence.
Yes. But my Lord, if I can draw your attention to what was held, page 565, tab 27, page 565. And what was held by your lordships is that the Article 4 of the Criminal Evidence Northern Ireland Order 1988 had been intended to change the law and practice as to the inferences which could be drawn from the failure of a defendant to give evidence. And what we respectfully submit, that is exactly what has happened in St. Lucia. The provisions which we challenge are intended to change the law and practice as to the inferences which could be drawn from failure to give evidence. And I want to...
Your case is, as I understand it, just as in Murray, the impugn provision was intended to change the law, and in those circumstances, in those constitutional arrangements, it was possible. In St. Lucia, you say it isn't because of the terms of the Constitution.
That is correct, my lord.
Got it.
Very well. Very well, my lord. And so I think it does not, given what your lordship has just said, I don't think I need to elaborate too long, my lord, on point G, which is that public interest arguments are mute, in that when one looks at what I call the proviso in the Constitution itself, Section 1, tab 1, page 190. The last, what I call subparagraph, the provisions of this chapter shall have the effect for the purpose of affording protection to those rights and freedoms subject to such limitations of that protection as are contained in those provisions, that being the provisions of Chapter 1, being limitations designed to ensure that the enjoyment of the said rights and freedoms, which we respectfully submit includes the right to silence, by any person, does not prejudice the rights and freedoms of others or the public interest. So, to the extent that there are limitations on those rights, they are to be found in the Constitution itself, and those limitations that are there take into account. The framers of the Constitution certainly were alive to the issue that there will need to be limitations having regard to the public interest.
Well, let us suppose there was a phenomenon of every defendant producing a defense at the last moment, which the prosecution wasn't able to effectively counter. Would it be in the public interest that something be done to modify the law to ensure that that did not happen?
If that was considered a problem, Parliament could employ what we say is the proper means and pass an amendment so that that problem in the public interest can be eliminated or eradicated. And
the amendment of which you speak is an amendment of the Constitution.
That is correct.
That's your case.
Yes.
The key point you're making is that whatever other constitutions or documents say, you say in St. Lucia, the limitations have to be found in Chapter 1 of the Constitution itself. Parliament cannot enact.
I mean, the difficulty here is that Chapter 1 is basically, as has been held, in the form of a recital. But, beneficently, the words of protection of the law have been extracted from it and have been given a substantive, separate understanding, which is wider than Chapter 8. So there are no specific limitations for protection of the law, but may I suggest to you that the protection of the law itself is a qualified concept. In other words, you have to ask what is involved in the protection of the law by reference to some value or standard, and I would suggest that the standard is a fair trial.
Yes, well, what...
So it's a circular point. You're back at the question, since a fair trial is inherently something which may involve a balance, you're inherently back to the question whether the law which was introduced was fair.
Yes, what we would say in response to that, my Lord, is that the Section 8 does, in fact, contain certain limitations.
Yes.
It's not a free-for-all, and we have identified that in our written case.
Well, if you're within the scope of Section 8, you're either dealing with what is a fair hearing, which is the same point that I've been putting to you under a different guise, or alternatively, you have to bring yourself within one of the specific subsections to Section 8.2, don't you? Or Section 8.7. Yes.
Yes, my Lord, if I could just be handed one...
In which case, as you say, there are some...
Well, the other point I want to make, because I do say that there are certain limitations that are expressly given in Section 8, the section that deals with the protection of the law. And what we would also wish to say that the right to silence and the right to, or the right against self-incrimination, the privilege against self-incrimination, those rights have been repeatedly stated to be at the heart of the right to a fair trial, at the heart. And so what we say that where there is a diminution of a right that is at the heart of a fair trial, we think an argument can be made, and we are making the argument that invariably and inevitably will have consequences for the trial. It's not a peripheral right. It's not a peripheral right, something at the edges, marginal. It is at the heart.
Yes, but whether it's at the heart or not, what you have to try to persuade us of is that this inevitably impinges upon the fairness of the trial. And the contrary argument is a reasonably straightforward one, and that is that there's nothing inherently unfair about requiring a defendant to signify whether he has a particular line of defence. That doesn't impair the fairness of the trial.
Well, my Lord, we would like to look at the right to silence as has been what it entails and the unfairness that would arise.
Your complaint is related to a situation where you have chosen to speak eventually, and the inference is being derived from the fact that this is something which you could obviously have given earlier warning of. You don't have to speak, so there's nothing compelling you to give evidence or to make this point. All that the legislation is requiring is that you give the prosecution some notice in advance to avoid, as my Lord put you earlier, taking everyone by surprise.
Yes.
And aborting trials or actually distorting the relationship between prosecution and defence.
Yes. What I would say, my Lord, if you can, my Lord, return to the case of Gilbert, tab 35.
35?
Tab 35.
Thank you very much.
Gilbert, which begins at page 717. And this was a case where a person, an accused person, did in fact raise quite late in the game his defense, the defense of self-defense. The Gilbert case, which begins at page 717, and what was held at page 719 of the record, page 239 of the judgment of the report. Page 239 of the report at the top. What was held is that the trial judge, in asking the jury to consider whether it was remarkable that when making his statement to the police, the appellant said nothing about self-defense. In doing so, the judge fell into error and misdirected them.
Yeah.
And what we say...
But that was by the standards of that day, and it's significant, of course, that it was the court went on to hold that there was no miscarriage of justice. And one might say that that is synonymous with the trial not being unfair.
Well, in the particular facts of that case, but the principal point being, it could be that a person could be convicted as a result of a misdirection. And the courts have certainly, the appellate courts have certainly held, yes, there was misdirection there, but at the end of the day, no miscarriage of justice. But the point is that the asking the jury to draw an adverse inference.
Yeah. But he didn't go through the hurdles which the current legislation requires of considering whether there was a prima facie case and so on. Is that not the position?
Well, the current legislation in St. Lucia certainly contemplates that the matters would have advanced at a certain point where the defendant more or less would be called upon to give an answer.
It might be worth having a look at 723.
723? Page 723?
Yes, down towards last paragraph but 1 on 723. If you just read to yourself, would you, the paragraph which begins, "He rightly told the jury."
Yes. He rightly told the jury that no adverse inference was to be drawn in the circumstances where he did not disclose his defense to the police. And what we...
As the law now stands,
yes,
although it may appear obvious to the jury, as a matter of common sense, that an innocent man would speak and not be silent, they must be told that they must not draw the inference of guilt. There are, as the judge pointed out, those who think that the law should be altered.
Yes.
And look at the 245 is an even more explicit.
245?
245, the top two paragraphs, referring to the fact that the Criminal Law Review Committee had already recommended the change in the law.
Right. And what we say is that to the extent that there ought to be these kind of changes,
Yes.
in the case of St. Lucia, these changes ought to come not by means of ordinary legislation.
Yeah, well, we understand that.
Not that.
That depends entirely upon whether you can find in the Constitution an absolute principle, and we've suggested to you that the principle which appears to be applicable is one of a fair trial or fair hearing, which isn't an absolute principle. It depends on a value judgment.
Well,
according to the circumstances and according to whatever modification is made to procedure.
yes, well, my Lord, certainly looking at case by case, a court has to decide and to ensure itself that a fair trial has been obtained in the particular circumstances of that case. But we are concerned not about the particular circumstances of a case. We are talking about a change in the law.
Yes, but listen, Dr. Dorset, you do have to separate out the various things that might be referred to under the umbrella expression, right to silence. We've already had Murray, which was a case which concerned the right not to give evidence at the trial. That's in English language now, there's no reason why you should be familiar with it, but that we now have a specific section, Section 35 of the 1994 Act, which deals with that. This is inferences from omissions from police interviews. We also now have a separate section dealing with that. You've reproduced it for us somewhere, I think, Section 34 of the 1994 Act. Now, there's room for lots of views about both of those provisions, but do you say that the present provisions which are under discussion, the requirement for a defence statement, is akin to either of those?
The changes that have come about by the English law?
No. Do you say that the requirement to give a defence statement, which in the St. Lucian law, which is what we're here to argue about, is the equivalent of either the modern English Section 35 or the modern English Section 34?
No.
Because it isn't, is it?
It is not. But what is common to them,
Yes.
and this is the critical point of complaint, is the adverse inferences.
I see.
Yes, we recognize that the right of silence can manifest itself in a number of ways. At its base level, a change in the law, which change allows for adverse inferences, we find, or we argue, is a change that if that change to be made, ought to be made by amendment. My Lord, I would want to draw your attention to the second Murray case, Murray versus the UK. Because as you would look at the Court of Appeal judgment, they seem to rely, and it says that they are applying the Murray case to say that the sections of the law that we are challenging are compliant with the Constitution. We say because those new provisions allowed for adverse inferences are not consistent. And in particular, my Lord, the Murray case begins at page 577.
Right.
Tab 28, page 577. And at particular page 578, what was held? What was held? Where the court said, it pointed out that its role is not to examine whether in general the drawing of inferences from exercising the right to remain silent is compatible with Article 6. In this case, we are saying that a law which applies to all accused persons, a law of general application, where adverse inferences can be drawn from the exercising of the right to remain silent, such a law is not consistent with the Constitution of St. Lucia. All that the Murray case decided, and you will see it there, my Lord, from the head note, the court in the Murray versus UK case confined itself to the facts of the present case. And in looking at the facts of the present case, they determined that there was not an unfair trial and hence no violation of Article 6. We are making a different argument. We are asking the court to look to do what the European Court did not do. The European Court did not examine whether in general the drawing of inferences is compatible with Article 6. We are asking the court to make that examination and to find that the drawing of inferences is not compatible with the Convention.
Hang on. I mean, I understand what you're saying, but I mean, if the Strasbourg Court had taken the view that the drawing of inferences was a matter of generality contrary to Article 6, which is what you want us to say, Murray would have been decided the other way, wouldn't it?
That's right. And that is why
So do you say the case helps you or hinders you?
it ought to be distinguished, because we have to understand the decision in Murray is to a limited point.
Yes,
It's
but
not all that limited. It's that it confined itself to the facts of the present and considered whether the drawing of inferences rendered the applicant's trial unfair.
Yes.
And concluded that it did not render it unfair. So it strikes at the heart of your appeal, does it not? That the drawing of the inferences is not self-evidently a vehicle by which a trial becomes unfair.
Well, my lord, what I would say is that we ought not to be in a position where this type of analysis has to be going on, case by case by case by case. The law is intended to, people should know where they stand in terms of, do I have the right to silence to the extent that no advertisements can be...
we are concerned with very specific legislation which explains how the process works and what the consequences are. Whether a fair trial has occurred is always a case-specific issue. Here, we're working within a pretty narrow parameters in considering whether unfairness occurs in the light of these specific provisions. So we're not dealing with some general question such as you're posing to us.
Right, my lord. Well, let me take you, my lord, to what was stated in the Smith case, where the right to silence was examined in a fair amount of detail, my lord.
Yes.
Yep.
Smith, you said.
Smith.
Must have.
Where do we find that?
My learned friend was kind enough actually to provide a copy here this morning. It is not in the bundle. We have referred to it, my lord, at paragraph 78 of our written case.
You need the report, I think.
Yes. The report, yes, the Smith case, yes. Very grateful for the assistance there.
Thank you.
And
Very much.
I would draw your Lord's attention to what was said at page 32. Page 32, letter A to B, where there was a fairly extensive analysis of the various dimensions of the right to silence and what it involves.
Do you mean 32 or do you mean 30?
Yeah, it means 32.
It is contrary.
Oh, contrary to fair play, yes.
Yes. It is contrary to fair play to put the accused in a position where he is exposed to punishment. Whatever he does, if he answers, he may condemn himself out of his own mouth. If he refuses, he may be punished for his refusal. And that, my lord, is the subpoint, the predicament, what I call the predicament identified in Smith. This is the predicament that accused persons now face, which in the Smith case, it was a predicament, what we call a predicament, that is contrary to fair play, to use the words of Lord Millett. And we say, whether it be Sexius or John Doe, James Smith, this predicament identified by, I think it's Lord Millett.
It's Lord Mustard.
Lord Mustard. In this particular case,
Yes.
is a predicament that faces all other persons.
Well, yes. The analysis that Lord Mustill gives to the right to silence, which is usually quoted, is at 30, isn't it?
Yes.
It breaks it down into half a dozen frequently encountered elements, which doesn't actually include any question of whether you can be required to give some advance indication of the issue, what the issues are going to be at the trial. But never mind that, it just doesn't. The provision in question in Smith was provision of the Criminal Justice Act 1987, wasn't it? It was a provision under which
That is correct.
provision under which in a serious fraud case, the Serious Fraud Office was entitled to require anybody, including a defendant, to answer questions on pain of punishment if they didn't. So it was a reversal, if you like, of the ordinary position of police interviews where you're cautioned that you don't have to. And that is what Lord Mustill is describing. That would, in your terms, be the clear, you would say, an infringement of the, I suppose, of the right to a fair trial.
Yes, well, we recognize that Lord Mustill, I hope I'm...
Yes, it is, you're quite right. And interestingly, after this case, a little time afterwards, I rather fear, but after this case, the Act was amended to make it impossible to require defendants to answer questions in this form. It's a new section 8AA, but all that's history.
Yes, yeah, well, I think what is not history is the principle.
No, I think you're not reading this correctly. Lord Mustill, having set out on page 30, as my lord's pointed out, in the top of 31, a whole series of different types of immunity, then says in 31B to C, it's necessary in particular to keep distinct the motives which have caused them to become embedded. He then sets out a whole series of motives, of which the one you read is, I think, motive number 3. And then at 32D to E, he says that you can't deal with it in general terms, that's, I'm paraphrasing the first sentence, rather an essential starting point must be to identify what variety of this right is being involved and what are the reasons for believing that the right in question ought at all costs to be maintained. So you've got to consider the context, and as my lord points out, actually none of the context he was considering was the present one. That's a problem for a start. But then secondly, even if it were one of the contexts he was considering, you have to treat it separately and ask, is it a right in question which ought at all costs, I think he means without any qualification, be maintained? So we're back at the same question. What is the nature of this right? Does it infringe some general principle?
Yes, well, certainly...
Is it such that must at all costs be maintained, or are we simply within the value judgment area of whether there's a fair trial, in which case it's not an absolute right, it's a value judgment?
Well, yes, to the extent it's a value judgment. But to answer that particular concern, my lord, I would want to draw your attention to what was said in the Petty case.
Petty?
Petty.
Petty.
And I have, that case is to be found at tab 29. Just after Smith.
New South Wales, yes.
Yes, it's the same point as Gilbert, isn't it?
Yes, just hold on, my lord. Where they approved what was said in Gilbert, and I would want to, in Gilbert, the point was made that in drawing inferences, we could arrive at a situation where the right, and I'm looking, my lord, particularly at paragraph 79 of our written case, page 147 of the record, where I've highlighted the essential extracts that I would want to highlight from the Petty case, where it was stated that an incident, I have highlighted it, page 147, an incident of that right of silence is that no adverse inference can be drawn against an accused person by
Sorry, I'm not. Which page did you say it was?
of the record, page 147 of the record, page 147.
It's page 31 of the appellant's written case.
Page 31 of
the skeleton.
of your case.
Case, yeah.
Of the
You want the quote? Where's the quotation in Petty? It's at, in Petty. It's at.
It will be at about page 99.
Thank you very much.
Yes, it is.
99 it is.
Yes. And I have highlighted the words. It
Yes.
begins at page 99
Yes, it's page 628 of the
of the record.
MS page 628. For those of us who are doing it that way.
Yes. And I have highlighted what was stated. An incident of that right, that is the right to silence,
Yeah.
is that no adverse inference can be drawn against an accused person by reasons of his or her failure to answer such questions to provide such.
Now this is police interviews, isn't it?
That's right.
Okay.
But the principle here is the drawing of adverse inference in whatever circumstance.
Well,
And to soar to
No, by reason of.
you've got to distinguish what you're inviting anybody or allowing anybody to draw an adverse inference from. But you're quite right. It is about adverse inferences.
But the thing is that with in certainly as I have, to the extent that my research has tried to unveil where this phenomenon has developed, it is not in place, say in Australia, the requirement to file a defense statement.
Yes.
Likewise in South Africa, Canada. It is something that
I think you may find it varies from state to state in Australia now. I'm not sure about that, but you're quite right. It didn't apply in this case.
yes.
At least it doesn't appear to have done. But in any event, it wouldn't have been relevant to this case because this case is about failure to answer police questions. It's not about a requirement to give some indication of what the issues are going to be at trial. And we need to focus on whether a requirement to give an indication of what the issues are going to be at trial is an infringement of the right to silence at all.
Yes. My Lord, with respect, I would agree with you that in the facts of this case, certainly the dicta here, indicate that the facts here is remaining silent when asked questions by the police.
Yeah.
But my Lord,
But the
makes
principle-
my Lord makes a more fundamental point to you, and that is the question whether being required to give an indication of what is an issue in the trial is in fact something that touches on the fairness of the trial. That's the fundamental point.
Well, certainly that is the case being made by the respondent, and what we say is that it ought not to be so.
Well, the authority relies on may be wrong. Let's face it.
What we say is that the common law, where a defendant could at trial disclose what his defense is, that is what was codified in the Constitution. The right to silence. That is what it was understood to mean.
Well, the effect of it certainly was that he could keep quiet and ambush the prosecution at the trial. That's clear as a matter of common law before it began to be affected by things like requirements to give notice of expert evidence, requirements to give notice of alibi, and so on and so on. But at some stage, Dr. Dawson, you must do it in your own time, but at some stage, are you going to address the question of whether these rules that you're complaining about in St. Lucia, which require the defendant to give advance notice of what are going to be the issues at trial, is in fact any impairment of the right to silence at all?
to the extent that adverse inferences can be drawn if they're not disclosed.
Let's start with whether it's an infringement of the right of silence, because if it isn't, there's no problem with drawing adverse inferences, is there?
Well, we say the infringement arises not so much by the disclosure, but by the fact that adverse inference can be drawn if there's non-disclosure.
Well, not so much from if there's non-disclosure as if something happens at the trial which is inconsistent with what you've previously either said or not said. Now, I mean, as I say, please take your time and come to it when you're ready. But we do need your help, I think, about whether these rules require a defendant who is going to sit in the dock completely silent and take no part in the trial at all, which he's clearly entitled to do by Section 8(7), whether these rules require him to say anything at all in his defence statement, except that he disputes, he puts the Crown to proof.
If I may be permitted to say.
Well, come to it when you're ready.
Well, my lord, I think I am ready.
All right. Thank you very much.
Good.
The defence statement does not have to say anything of substance. But, and this is where we say the infringement arises, the fact that the defence statement may not disclose anything of substance, adverse inferences may be drawn, and that is where the violation.
When?
I see.
When the adverse inference is drawn.
No, but in what circumstances?
Yes. If the defence statement says nothing and the accused doesn't lead evidence, can the court then direct the jury that they may draw adverse inferences?
Well, I think that is what the section.
But you shouldn't do it, should you? If you have a defendant who says, do your worst, I'm not helping you at all, I'm not telling you anything about my case, I simply say, go on, prove it. And he says that in his defence statement. And then at the trial he sits tight, he doesn't give evidence, and he doesn't call evidence. He doesn't advance by way of cross-examination any positive case. He simply sits there. Could anybody then tell the jury that they could draw an adverse inference from his behaviour?
Well,
couldn't possibly, could you?
Well, my lord, I would want to answer that question, I would want to look specifically at the words of the...
Yes, well, I think you can do, at page MS 2110. I'm not myself even sure that an inference could be drawn if he cross-examined. It depends whether that would be regarded as being putting forward a defence different from any defence set out in the defence statement. But otherwise, I mean, if he simply says, I think he's more likely to say probably, I'm not guilty, the evidence comes nowhere near showing that I'm guilty. And then he sits tight.
My lord,
no inference could be drawn, could it?
Well, my lord, to answer the question, I'm looking, my lord, at page 210,
Yep.
Yes.
section 912 of the Criminal Code, where it speaks in subsection 1, the...
yes, we can read it. Which one is?
Yes, the defaults.
Your point is that it is at least technically open to direct the jury that it can draw an adverse inference from a failure to give a defence under Section 908. Right. The question, however, is whether it would even conceivably be proper to do so.
Surely this is a mistake, isn't it? It must mean failure to give a defence statement under Section 909.
Yes, it must.
Yes, I think...
So, I mean, failure to give a defence is...
it can't be 908 because 908 is disclosure by the prosecution.
So let us assume it says failure to give a defence statement under Section 909. Then he will have given us a defence statement if he puts in the denial, which we've been suggesting to you.
Yes, my lord. But what the section provides, in the case of these defaults, is that the court, or with leave of the court, any other party, may make such comment as appears appropriate, or the court or jury may draw such inferences as appear proper in deciding whether
Yes.
the accused committed the offence or not. And so,
What I'm saying to you is that if he maintained the same blanket silence at trial, it would never be proper to direct that an adverse inference be drawn, because that would be to infringe Article 8(7) of the Constitution.
yes, and what we say, this type of discretion ought not to be put in the hands.
Of the judge.
That's right.
Can't be trusted to get it right.
Well,
Court of Appeal can't be trusted to say if he gets it wrong, appeal allowed, conviction quashed.
that point, my lord, was raised in the Murray v. UK case.
Right?
Murray v. UK, tab 28.
Yes, you want to give the page reference, my lord?
I think I've got it.
Page 577.
577.
Right, the Murray case again, right.
And I would want to draw your lord's attention to page 45 of that particular judgment.
593, yeah.
It is at page
Yes,
593
I have it.
of the record.
Yes, we have it.
And this was
Which
reported,
paragraph, please?
paragraph 59. The commission notes,
Yes, well, and this is putting what my lord's put to you, namely, that discretion is actually something that judges are given and the Court of Appeal can correct. If it...
yes, but what in Northern Ireland, the judge can write his reasons.
Yeah.
And so there is that kind of control or safeguard. But in the case of a jury, if a jury given that direction
Well, that's the point. What direction?
to draw adverse inference,
But you can't possibly, that's the whole point. The judge must decide in each case whether to allow the jury to draw an adverse inference or not, and he must tell them either they can or they can't.
And if he gives the wrong direction, he's just as amenable to appeal as a judge in Northern Ireland who has to give a written judgment.
Do it all the time, Dr. Dorset. And what's more, because it will be a subject of argument between counsel, the judge will first rule on it in the absence of the jury, and his ruling will be transcribed and available to the Court of Appeal.
well, we accept that, but what the point that we would like to make is that why should accused persons have to live in that hope?
I follow.
Yes, if things go wrong because of this act, which we say is unconstitutional,
So there should be no risk
there
to
should be
the
no
accused.
risk. That's right.
Okay.
It's a constitutional right. And in particular, to support my point, this was at page 53 of the Murray case, page 601 of the record. I would just say that in this particular, it's a partly concurrent, partly dissenting opinion, but it is important to recognize that this particular judge, Mr. Bratzer, and you can see it, my lord, at page 603. Page 603, at the top of the page. For these reasons, I agree with the majority of the commission that the drawing of inferences for the appellant's silence did not deprive him of a fair trial. So he agreed with the majority in the finding in the Murray case. But he makes an important comment at page 601 of the record.
Right.
Point 1, line 4, towards the bottom of the page. Well, I think I would read the whole paragraph.
It's the reasoned judgment point, isn't it?
Yes.
Yeah.
And he says, in the case of a jury, we are in a little different territory there.
Yes.
Yes. And so,
That would be right if it weren't a matter for the judge what direction to give the jury.
and then,
But it is, isn't it, a matter for the judge? After all, you wouldn't expect the jury to have read Section 911 of the Criminal Code, would you?
No, they're persons.
So there's no danger of them doing it off their own bat. And indeed, one would have thought that if there was any risk of them doing it off their own bat, the judge would be failing in his duty in a case in which it would be wrong to draw an adverse inference to abstain from telling them. You mustn't hold it against him.
Yes. Yeah, yes. That in the current case, under the law prior to the introduction of these provisions, there was no risk
Yes, I see.
of adverse inferences being drawn,
It's the risk.
by judge or jury.
Okay.
Now there is that risk.
Yeah.
So,
Well, I think this is Mr. Bratzer. He's the only one who expresses that distinction, isn't he? And he is doing it in the context of a different type of adverse inference drawn from failure to answer police questions, as well as not giving evidence at trial.
well, my Lord, with respect, I think the point was also referenced or certainly foreshadowed at page 45, which I had referred your Lordships earlier, where the fact that...
In the Commission's opinion?
Yes,
Yes,
that's right.
quite right.
Thank
so
you. Yes.
it's mentioned at
Yes,
least twice.
that's helpful. Yes, right.
Actually, no, beg your pardon.
The Commission opinion.
It is,
59. It is,
59 is the Commission's opinion. But he wants...
or it's a record of what the Commission...
And it is incorporated in...
It is the Commission, isn't it?
Yes, it is.
Yeah.
My Lord, looking again at section 912 of the code.
Section 912?
Yes.
Yes, quite.
What page, please?
Of the code, I'm now, my Lord, at page 211 of the record.
Thank you.
211. Subsection 2 of section 912, where it says that a person shall not be convicted of an offense solely on an inference drawn under subsection 1. And what we say is that if a defendant, an accused person, is convicted, how is he to know? How is he to know that the conviction came down because of that additional inference? It could be that the evidence was on the brink of proof beyond reasonable doubt. But then the inference brought the conviction. And I want, my Lord, to highlight that point by reference to an article entitled Emergency Rule, Normalcy Exception, the Erosion of the right to silence in the United Kingdom.
Yes.
Now, my Lord, I understand and I accept that we're dealing here, at least the article here focuses on the Northern Ireland Order. I recognize that. But I raise the article to speak to the issue of adverse inference. Because it is adverse inference that we seek to guard against with the right to silence in its traditional sense. And when the order came down in Ireland, at first, and this was a case, R.V. Smith, where it was stated that it seems to me, and my Lord, it's at the indented words at page 500 of the article, page 500 of the article, 500.
Yeah.
When shortly after the introduction of the Northern Ireland Order, with respect to how adverse inferences could be drawn. This is what was said. It seems to me that in some cases, the failure of an accused to give evidence may justify a finding of guilt where the weight of the prosecution evidence just rests on the brink of the necessary standard of proof. That is what was stated in October 1989. And what the article shows is that over time, the standard changed so that when we get to page 503, the same judge, Judge Kelly, dealing with the same Northern Ireland order, speaking of, he says, in the Raymond Smith, the case that we just referred to, where he had made certain statements. In Raymond Smith, I gave such instances in broad and general terms as to what may be the consequence of the application of Article 4. But I add to these another instance only to show the width of the parameters of Article 4, where adverse inferences can be drawn. That in certain cases, a refusal to give evidence under the article may well in itself, without more, increase the weight of a prima facie case to the weight of proof beyond a reasonable doubt. And that, my Lord, was said in December 1990. Shortly within a year, you can see what has happened, the width. And later in the article, after that quotation, Judge Kelly, in arguing against providing guidelines for the order's application, stated, it would be improper and indeed quite unwise for any court to set out bounds of whether to draw inferences or not in an individual case and the nature, extent, and degree of adversity if it draws or if it decides to draw adversity. And what we are saying, my Lord, is that we are concerned that the same phenomenon that seems to have manifested itself beginning out of Northern Ireland, where there is a unique history, and I need not get into the unique history of Northern Ireland that led to these provisions. That unique history led to these provisions where adverse inferences can be drawn from silence. And to deal with the unique history, the thinking of the court evolved to the point, within short order, where when a person exercising the right to silence, it could be said that the failure to give evidence, the exercise of the right, may well in itself, without more, increase the weight of a prima facie case to the weight of proof beyond a reasonable doubt. That is when, of course, conviction arises, when it's a case, there's proof beyond reasonable doubt.
We may have to say something about what is meant by Section 912(2), whatever the outcome might be. I mean, it doesn't actually indicate what standard is expected to be met.
Well, 9122 is a direct copy of the English, first the Northern Irish and then the English provision, isn't it? It's a direct reuse of the English provision.
Well, it started not an island, and I think it came over here.
Yes,
Precisely.
that's what my Lord has put to you.
Precisely. And what it means, at least in English law, is that there has to be other evidence apart from the inference, which there would be in both of the two instances that Lord Justice Kelly gave on pages 500 and 503.
Yeah,
Because in the first case he's talking about it just a case which is even without the adverse inference teetering on the balance, and in the second case he's talking about an instance where there is a prima facie case, but you're not quite sure that it's beyond reasonable doubt until you add the adverse inference.
and what we say is that if it is a case, my lord, where the evidence reaches to the point where the standard of proof has been reached in terms of proof beyond reasonable doubt, and if a defendant chooses to say nothing, well, he may be condemning himself.
Well, in that case, the adverse inference is useless.
Surely you're complaining about the legislation, but here the first question is what meaning should be put on this, and my lord's indicated the position over here, and we've seen the position as it's explained in these cases. Now, it may be that the standard should be put as high as it was put by Lord Justice Kelly first time round, but we can decide that, and we can decide if the legislation is otherwise fair, what fairness requires in relation to that point. And it doesn't affect then the validity of the legislation. It's simply that it may need to be construed in a particular way in order to be fair.
Could I just say how it works? Because I do understand your point, that it's the adverse inference, which is, you say, the vice.
The vice, that's what, yes.
Of all this.
Yes,
As I understand it, you agree that the rules which require a defendant to give advance notice of an alibi are perfectly consistent with the Constitution.
Yes, because that was the position in 19...
Well, and also, are they perfectly consistent with a fair trial?
Yes, because that is what that is what came into being with the Constitution.
Yes, but no, forgive me, I ask a separate question. Never mind whether they were there at the time of the Constitution or not. Are they perfectly consistent with a fair trial taking place?
Given the nature of an alibi.
Right.
Yes.
Now, supposing the defendant says in his alibi notice, I was not the robber, I wasn't there at all, I was at the football match, a mile away. When he comes to give evidence, because they've made a check on the cameras at the ground, or perhaps for some other reason, but at any rate, when it comes to trial, he says, well, actually, I wasn't at the football match, I was with my wife at home. Now, when it comes to deciding whether he's guilty or not, and whether either of those assertions is true or not, is the jury entitled to draw an adverse inference against him from the fact that he has changed his story?
The way I would answer that is that he failed to abide by his constitutional obligation.
What constitutional obligation?
In the case of an alibi, you are required.
Well, not by the Constitution.
Well, we say that the Constitution...
Anyway, he's failed to abide by his obligation, wherever it comes from.
Yes.
But are they entitled to draw an adverse inference from the fact that he has changed his story?
On the point of an alibi, I think yes.
Right.
On the point of an alibi.
So an adverse inference is all right in some circumstances?
In the case of an alibi... And
why is alibi special?
Because of the pre-existing law.
Yes. And special defenses.
Well, yes, I was going to ask about special defences,
Yes.
but no doubt you'll get to there's a definition somewhere. In fact, there are two definitions, and they're not quite the same. But,
yes, my lord. I think, it is common ground between us that there is a requirement that there be disclosure of that, because that was of alibis and special defenses.
Well, yes, I understood your answer. That's because it was the law,
Yeah.
what, prior to the Constitution.
Yes.
You could make a comment on that.
And what we say is that that law, under the principle drawn from the Vincent case, the Constitution codified that.
I thought we got away from that. I thought that these constitutions were, including that of St. Lucia, were recognized as containing rights which could alter previous common law rights. I.e., they contain a higher level of principle which was deliberately introduced and didn't necessarily precisely reflect or wasn't confined by common law rights. But you say the contrary. Vincent.
Yes,
Yeah.
yes, from Vincent.
What about the rule about disclosing an expert report? Was that in existence at the time of the Constitution? Bet it wasn't.
I can't speak with any authority.
Very unlikely.
No, I'm sure it wasn't.
It will have come later, won't it? But that's the same again, is it? If you fail to disclose an expert report, which you're bound to do nowadays, would a jury be entitled to draw an adverse inference against you from the fact that you've kept it up your sleeve?
Perhaps we can give a little bit more time to think about that.
All right.
The expert.
It's not directly analogous, but it's quite similar.
Yes, but I would certainly want to address it if I can just give a little bit more time to.
All right.
To ruminate on it. Yes, my lord. I was, if I can be permitted to refer back to, I had indicated that there were in fact certain limitations on the right to the protection of the law. And what we say is that that can, in fact, when you look closely at sections 8.2, 8.3, 8.5, 8.9, 10, 11, and 12 of the Constitution, one does, in fact, find that they are, in fact,
What does one find then?
limitations on the right to the protection of the law. So the Constitution, in and of itself, when it comes to the protection of the law, does in fact, at Section 8, expressly gives limitations. Mm-hmm. And what we say, there be no express limitation on the right to silence. It ought not to come in by means of ordinary legislation.
So where do you find the right to silence, then?
We say it's an implied right, but as we cite the authorities, including the case of McGuinty versus Western Australia, that certain rights can be implied when one looks at the text and structure of the Constitution, and it would make a nonsense of the right to silence as expressed in the Constitution, a right at trial, if such a right to silence did not exist pre-trial.
Why would it make a nonsense if it didn't affect a fair trial? Why wouldn't it be covered sufficiently by Section 8, subsection 1?
Well, we say, my lord, first of all, if one considers that it is, in fact, a constitutional, the right to silence is, in fact, a constitutional, it is more than just a common law right. A right that is at the heart of the fair trial provision, as the European cases have said. We find it, well, we make the argument that anything that strikes at the heart of the right to a fair trial invariably and inevitably limits the fair trial.
Right.
And what I would say, without being too graphic, if one amputates a finger, one may not die. But if one amputates the heart, one minute. The authorities are clear. The right to silence is at the heart of a fair trial.
There seem to be three different types of the right of silence, which we've been discussing. One is at arrest and charge. The second is a pre-trial, which is to do with the defence statement. The third is at trial. So there are three different aspects. Now, do you think it's relevant that Article 8.7 refers to the third of those, but Section 8 of the Constitution doesn't refer to the other aspects of the right to silence?
Yes, well, as I have indicated, my Lord, by looking at the case of the AG of Barbados versus versus Joseph and Boyce, and I have referred to that, my Lord, in my written case at the bundle, page 121 of the record.
Paragraph?
Well, it's paragraph 9, which begins at page 120.
Yep.
And the relevant extract
Yes.
is at page 121,
Not exhaustive.
where I have highlighted what was said by the Caribbean Court of Justice. And this was dealing
Well, I mean, this is the point we went to right at the very beginning, on which we have accepted that protection of the law can go, in some circumstances, wider than Article 8.
Well, it is in response to the question from my Lord, where he says, well, the right to silence is expressly mentioned at Section 8, but other formats or dimensions of the right to silence are not mentioned. And I says...
Yes, but it begs the question as to whether the right to silence is an absolute aspect of the protection of the law, whether it's an absolute, which is within the concept of protection of the law. It also, one wonders whether protection of the law in this context, where you're dealing with a domestic criminal trial and its various stages, was intended to go wider than, or much wider than Article 8. But we can leave that aside and assume it was. It still raises the question whether it embraces, as an absolute principle, no adverse inferences.
My Lord, if I can take the case of Herbert.
Yes.
I have referred to it at page 125 of the record, and the Herbert case, my Lord, is to be found at tab 36. But as you can see from the written case, page 125 of the record.
Paragraph 19, yes.
Paragraph 19, towards the end,
Yeah.
where it was stated there, from a practical point of view, the relationship between the privilege against self-incrimination and the right to silence at the investigatorial phase is equally clear. The protection conferred by a legal system which grants the accused immunity from incriminating himself at trial, but offers no protection with respect to pre-trial statements, would be illusionary. And that is what we say in answer to the question that was posed.
That's another police interview case, isn't it?
Yeah, well...
Herbert, yes, it is, yes. Okay.
Well,
but no, I understand.
I think it's inculpatory statements made to an undercover police officer placed in his cell, if that counts as an interview.
It's tricked by a stooge.
If I may say this, my Lord, that particular point of the right to silence may become illusionary. I want to marry that with what was said, and we have referred to it at paragraph 17 of our written case, page 124. Page 17. And I think it's an uncontroversial point that the construction of constitutional rights should not be done so as to produce anomalies and inexplicable inconsistencies. And what I would say, we would have an anomaly, an inconsistency, if adverse inferences could be drawn when the right of silence is to be exercised in one context, but not in another context. Inconsistency.
Herbert is nothing to do with adverse interests, is it? I may have been a bit behind the track in referring to it again, but it's dealing with, as my Lord points out, trickery, getting an admission by trickery, by an official, officer of the state.
It's dealing with admissibility.
Yes.
Yes, those were the facts, but the principle I would want to rely on, of general application,
Right.
is the idea that we do not want it to be illusionary. My Lord, you would have noticed that we have summarized, both at the start of our case, written case that is, and at the end. Well, before I do so, my Lordship led me in a way that was not quite in strict keeping with my planned outline, but I do want to refer to point 2, the pronouncement in Bowden, Tibbs and Wright. And again, we are dealing here with the vice, as your Lordship has indicated, the vice of adverse inferences. And referring to what was stated in the Bowden case, my Lord, is at tab 30. Tab 30. Mm-hmm. And what was said at page 827 of the report, page 827, letter F.
665.
Yes, 665 of the record. Speaking to legislation where the vice is present, it was stated in that case, the object of these sections was to weaken the protection which criminal defendants had previously enjoyed against the drawing of inferences adverse to them from such failures and refusals in the circumstances specified. In the case of English law, it is parliamentary sovereignty. Certainly, proper effect must, of course, be given to those provisions. It goes on to say, but since they restrict rights recognized at common law, which we say have come into being and force in the Constitution, since they restrict rights recognized at common law as appropriate to protect defendants against the risk of injustice, they should not be construed more widely than the statutory language requires. And what we say, Section 912(2) raises a risk that until now accused persons were not exposed to. With respect to what was said in the Tibbs case, the Tibbs case is at tab 42. And at page 315. 337. 15, page 837 of the record, 837 of the record. Just before letter B, that paragraph, it was stated there that we recognize that as the provisions in both the Criminal Justice Act 1967 and Section 5 of the 1960 Act diminish, that's what they diminish, the accused's right to silence.
Now, Tibbs is a case, isn't it? It's a bit like the alibi notice, and then the different alibi being run at the trial. Tibbs is a case where, where what the prosecution was trying to make use of was the fact that he'd said, not exactly black and white, but he'd said pink in his defence statement and crimson in evidence. Yes.
Well, I accept my lordship recital of the facts. But
It was a change of
yes,
account.
Yes, but the principle is that the St. Lucian law seeks by and large, to imitate the English provisions. Yes. And the English courts have recognized in clear terms that these new provisions diminish the accused's right to silence. And lastly, my lord, the Wright case, which was decided very recently, where I believe your lordship was referring in particular to Section 35, where the same vice is present. And this is what was stated. This provision, by the way, in terms of our written case, my lord, it is at paragraph 88.
We got it in the bundle.
No, we do not want to.
Paragraph 88, see whether that.
Yes.
Yeah.
It is in the
Yes.
footnote 5, towards the bottom, where Section 35 of the Criminal Justice and Public Order Act 1994 was considered by the Privy Council, where your lordship said, this provision, when introduced in 1999 into English law, had brought about a substantial change to the common law. And you can read the rest of it. I want to highlight what is stated towards the end, where there was discussion. And what was said there, that Section 35 of the 1994 Act reverse history. And what we are saying with respect is that these provisions which we are challenging, where the vice is adverse inferences, the vice, history is being reversed. And that is what is at stake here. These are not changes in law with minimal consequences. It's going to change the landscape. It's a significant change in the criminal law which affects constitutional rights. We, at this end, are not challenging the wisdom of the law. I think a strong argument can be made that perhaps the law should evolve to this. It has been adopted elsewhere. That argument perhaps can be made. But we say if that change is to be made, there is a proper route.
Yeah, it's the method of the adoption.
That's right. And
I think we've probably got that.
yes, and I would like, and that, my lord, concludes my portion of the presentation.
Can I just ask, this came into force in 2004, is that right? And it's been presumably applied domestically.
Mr. George can speak, because he's the man on the ground, he can speak.
Thank you very much. Yes.
But,
Now, you wanted a few moments to think about the expert report, so while I invite him to say anything, no doubt...
okay. With respect to
The requirement for
the
experts.
requirement of expert report, I think a strong argument can be made with respect to that it perhaps ought to be disclosed, given, I would say, because it's of its kind of unique nature. Just as there was an alibi, just as there was an exception for alibi defenses and special defenses, perhaps an exception ought to be extended to expert reports.
Thank you.
Given their unique nature.
Can I just ask about special defences, just in case it probably doesn't arise, but could you look at the transcript of the judge's judgment, which is at MS 25?
Yes, ma'am.
Which sets out her paragraph 41, the relevant provisions of the criminal procedure rules, which I don't think we've got elsewhere, at least not all of them. And she adds at the end of paragraph 41, just before you get to 42, the definition of special defence as it appears in the Criminal Code, section 6. Is this still its present form?
I suspect it is, but what I would say is that the code being the substantive law, that definition ought to prevail.
Yeah, no, I understand that. I'm just wondering about the ambit of it. Special defence includes, not is, includes the defence of alibi, duress, automatism, necessity, insanity. Well, one can see some arguably common features of some of those, or any defence tending to affect the question of liability of the accused.
Which could be...
What does that mean?
I can't quite say, my lord, with respect.
All right.
I can't quite say.
All right, thank you very much.
My learned friend might be able to get into the minds of the legislators, but I can't say.
Okay.
Thank you very much.
Understood.
Yes, Mr. George.
Lord, I wish to just point out, or rather to expand on what my learned friend said with respect to constitutional supremacy. And I would like to refer your lordships to section 120 of the Constitution, which is one tab 1. It's quite clear, as opposed to English law, and I think your lordships accept, that the Constitution of St. Lucia is the supreme law of the land. And as such, amendments can only be done in accordance with section 41. Section 41(2) in particular, and while we don't question Parliament's reason for its desire to improve the criminal justice system, we respectfully submit that it should be done in accordance with section 41(2), in that the respective provisions are entrenched provisions. And there is a requirement that at least when a bill is presented, that no less than 3/4 of the members of the House vote. This was not done in this case. And our submission that Section 909 and 912 is inconsistent with the Constitution, that having not been done, we are suggesting that the provisions ought to be declared null and void. But I further wanted to indicate to your lordships what actually happens on the ground. Most of the accused who interface with the criminal justice system are in fact unrepresented. Most of them, we have a mixed English and Creole-speaking population. We have approximately 20 to 30% of our population being illiterate or patois speaking, Creole speaking. Quite a large proportion of the persons who interface with the criminal justice system do not get legal aid. Although we have a Legal Aid Act, they do not get assistance except in murder cases where the state would provide legal assistance. Therefore, your lordships will recognize that in order to comply with Section 909 will be a tall order. In most cases, these defendants will probably incriminate themselves. And that is the real risk of these provisions.
Well, I see the risk. Are inferences drawn in those situations where a defendant has been acting on their own behalf?
Well, the inferences are being drawn in accordance with what is set out in 909.
Your concern isn't so much that they may expose themselves to adverse inferences as that they may treat the obligation to give a defence statement as an obligation to give an account, which may end up self-incriminatory.
Precisely.
Mm.
If it were the case, Milan, that these defendants were in fact always represented, then my concerns might have been different.
Presumably the judge or the magistrate at the preliminary hearing is telling these unrepresented defendants what they are required to do.
Not in terms of a defence statement, Miller.
But that arises, as I understand it, as part of a case management process before the magistrate or the judge, the local judge. So the local judge will explain, I assume, am I right, to the defendant who's unrepresented, you're required to do this, the defence statement means this, you must put it in by next week, etc. So they're guided. Would that be right?
Miller, when you look at the requirements of what is needed in a defence statement, you must first give what your general defence is about. Then you must be specific in that you must indicate the issues that you take with the prosecution's case.
But how does that work in practice when you have an unrepresented
Precisely.
Defendant coming before a judge? There must be some interchange. How does that work?
Precisely, Milan. Defendants understand that to mean they need to give a whole litany of facts.
Well,
that's the point.
I'm slightly concerned. I mean, obviously, the points you make are important points, but we're actually talking about advance notice of points, and I don't recall you're making any such point in your case. So it's not a point of which we, or indeed the prosecution, has had notice. There's no evidence. I mean, I fully understand what you say, and yes, local conditions are different, but I'm a bit troubled by the point being raised in this way.
Understandable, Milan.
Why, if this is the crunch point, this is a special point, that in the context, in the local context, this scheme works out unfairly, and there are no countervailing factors such as Sir Ronald put to you. We would have expected notice of that in your case.
Well, my lord,
And so I think with the prosecution, since they're not on the spot like you are.
Well, it doesn't
I
arise,
accept-
of course, in this case, does it? Because this gentleman was fully represented.
yes, he's represented. But I merely gave a practical perspective.
We understand the point, and it may be that my Lord's point is it makes a difficulty, a specific difficulty in raising it, because we're concerned potentially, or perhaps, with the justice in the particular case. Anyway, we have the point. Do you want to say any more on it?
My lord, I wanted to refer your lordships to the case of the Independent Jamaica Council for Human Rights versus Marshall Burnett, and it's a Privy Council case. It's at tab 23.
Can you give me the electronic page number, please?
521.
Thank you.
This is the famous Jamaican case, yes?
Yeah.
Right.
And that case spoke to the process in which Parliament should observe prior to making passing ordinary legislation. And I refer specifically to paragraph 21, which is at MS 536. At the bottom of 535, 19, H. And in that case, reference was made to what Lord Diplet said in the case of Hanks.
Mm-hmm.
And it said, it is clear in the opinion of the board that the present question must be approached as one of substance, not of form. And the approach commended by Lord Diplet in Hanks is that which should be followed. And with respect to our submissions, this is what we are contending.
Yes.
I further would like to refer, my lordships, to the bottom of page 536, MS 536, at H, where reference is made to the important function of a constitution, and it is to give protection against governmental misbehavior. And in this case, it referred to the Free Acts that gives rise to a risk which did not exist in the same way before. But we are respectfully submitting this is exactly what Section 909 and 912 is doing.
Well, that case is about entrenchment or risk of entrenchment on entrenched rights, namely the operation of an independent judiciary, wasn't it? It was held that change in the highest court of the land had that implication. Thank you, yes.
Thank you.
Thank you very much indeed. I think we will retire for just a moment to see where we are. Mr. Poole, we've had the benefit of very full submissions from Dr. Dorset, and we've had the benefit of his and your very full written cases. And having heard the submissions, and you've heard us put a lot of points to Dr. Dorset and to Mr. George, we don't feel that we need trouble you generally on this appeal to add further to what you said, but my Lord does have one or two questions which we need to put to you.
I just wonder, Mr. Poole, if you'd help us by looking at section 909 of the Code, which is the provision under attack, page 209 of tab 2. And generally the question is, what do you say on behalf of the St. Lucia authorities is required of a defendant by these provisions by way of a defence statement?
My Lord, we say, when one looks at section 909(2), spelling out the requirements, those mirror the equivalent provisions under the English Criminal Procedure and Investigations Act 1994, which your Lordship will be familiar with. But you can see the identical
perhaps too much, but others necessarily
My
aren't.
Lord, I take your Lordship's point. That's on page 233. So we say, by parity of reasoning, the English authorities that deal with the equivalent provisions setting out what's required by a defence statement apply with force in St. Lucia. And there's a judgment that your Lordships will find under tab 40, or page reference 823, which is a case called the Queen against Rochford. And in my submission, the Queen against Rochford is a authority for the proposition that it's a point that was put by my Lord Hughes to the appellant. Effectively, if an accused intends to advance no positive case, but simply put the prosecution to proof, then that is sufficient to meet the requirements of what was section 5 of the CPIA in England and Wales, and the equivalent provision under the Criminal Code of St. Lucia. And the particular paragraph of Rochford where one sees that is paragraph 16, which is page 828. The first question which we think ought to address is whether there is a failure to comply with section 6A. The answer to that is we do not know, and neither did the judge. If the defendant was going to say that he was somewhere else rather than in the driving seat, then there had been. If he was going to call evidence, then some other sorts other than himself. Then it goes on. Once the issue is going to be raised in any of those matters, section 6A, 1 little c, little ca would apply. Sorry,
where are you reading
so
from?
I'm reading from paragraph 16, which is page 828 of Rochford.
Thank you, yes.
And I had got to about 6 lines from the end of that paragraph. Once the issue is going to be raised in that way, would apply and require the defendant to set out what he took issue with the Crown in his location to give particulars of the matter as a fact. However, if the defendant was going to make no positive case at all and not raise the issue of his possible location elsewhere, and if he was simply going to sit tight and ensure that the Crown proved its case, then as it seems to us, there would have been no failure to comply with section 6A. And I say the same principle applies when one is examining the equivalent provisions of the Criminal Code of St. Lucia. So one can see what you are required to provide by way of particulars from the wording of section 909 little 2, but the same applies as it did in Rochford. If you're simply not going to advance any positive case, then that is sufficient.
Well, you have to say something, don't you? You have to, at least if Rochford's right, it may not be, but if Rochford's right, you have to at least put in your defence statement.
You put in your defence statement and you essentially say no more than we put the Crown to proof.
Yes,
that would meet the requirements in my submission of 909 little 2 in St.
In that event, in what, if any, circumstances could the possibility of the jury being directed that it was open to it to draw an adverse inference against the defendant arise?
If an accused who has put in a defence statement effectively saying we put the Crown to proof, but then chose to give evidence and advanced a positive defence, then that it would be open to the, well, first it would be open to the prosecution to apply to the judge to make comment, which is different to the position in England and Wales now. It used to be the case under the 1996 Act that you had to have the judge's permission. That has been amended, but the position remains in St. Lucia that you would have to apply even to make comment. And certainly, and this is now in 912 after the page 211, after you have the various circumstances spelt out when it is possible to draw adverse inferences or make comment. It says then the court, or with the leave of the court, any other party may make such comment as appears appropriate, or the court or jury may draw such inferences as appear proper in deciding whether the accused has committed the offence concerned. So this is, and you'll see in the respondent's written case, this is what we refer to as one of the numerous safeguards, actually within the terms of section 912 itself, but we say wider than that, the judge exercising his or her discretion as to whether or not comment is to be allowed in the first place, whether or not inferences are to be drawn, and the nature of the direction that's given to the jury. These are all, we say, important safeguards, leaving aside, but obviously of importance, section 912(2), the point being that no one shall be convicted solely on an inference drawn under section 912.
What does the section mean? It says the court, or with the leave of the court, any other party may make such comment as appears appropriate, or the court or jury may draw such inferences as appear proper in deciding whether the accused committed. I imagine it really means, and if a comment is made, then. Isn't that right?
Must mean that, mustn't it?
Yes. There are some infelicities, unfortunately.
We might, maybe that ought to be made clear.
It's pretty clearly and, isn't it? And, or if you like, and,
yes.
or, but anyway, it's.
Yes,
Maybe and in that case, perhaps.
Well, no, because you wouldn't, because the occasion for an adverse inference could arise,
yes,
even without the Crown having made the comment.
Yes. Indeed.
Whether, I mean, it might be relatively unlikely, but at least in theory it could.
Indeed. There's a point that is made by the Court of Appeal, and indeed I think judge at first instance, which is, if we're talking about infelicities of drafting, section 909
yes,
is entitled voluntary disclosure by accused. It's a point that
yes,
the Court of Appeal makes. I think, having looked, I think this has been lifted effectively from the 1996 Act, which under the 1996 Act, and you can see this page 233 and 234,
yeah,
drew a distinction between summary offences and indictable offences. And in summary offences, what was section 6 of our 1996 Act had the subheading voluntary disclosure by the accused in summary-only offences, whereas indictable offences, which was dealt with under section 5, had the subheading compulsory disclosure by accused. And I think the draftsman, when borrowing the word, didn't make that distinction, but it's obviously not causing any difficulties.
There is another thing that perhaps you ought to just address, Mr. Poole. We've been focusing entirely, understandably, on the impact of any failures to comply on the Crown's case. But any other party in 9121 after F would presumably include, wouldn't it, a co-accused,
yes,
who, after all, in some cases, is running an entirely contradictory case to the defendant whose case once thinking of.
Yes, indeed.
So the control of the court would be of even greater importance, perhaps.
Yes.
So what this section appears to do, at least, is to make sure that no co-defendant can make free with the defence statement without first getting the judge's permission. Is that right?
It is right. And sort of not having the benefit of sort of local knowledge. The point, it's a point that's made in our written case on really having taken instructions from the DPP's office. The actual procedure, practice and procedure in St. Lucia, as far as the DPP's office is concerned, is not to provide copies of defence statements to the jury. There is no express provision in the criminal code for that to happen, unlike in England and Wales.
Just remind us what the practice now is in England and Wales. They're certainly cross-served on other parties.
Yes, and well, you will see, I think we have the under tab 9, starting at page 238. This is the CPIA 1996 as amended by the 2003 Criminal Justice Act. And the relevant provisions at section (6E), disclosure by accused further provisions, subsection 4, the judge in the trial before a judge and jury may direct the jury be given a copy of...
Oh, yes, the judge can direct it, but it's not the practice to put it in.
No.
In the absence of a judicial decision, is it?
No, my lord.
Not even now?
No, that's quite right.
So, this legislation in section 6, as you, the voluntary disclosure by accused, does make the defence statement here voluntary. Where's the compulsory requirement?
Section 5.
That's section 5. Sorry.
Which
yes.
6E, to which 6E and
Yeah.
6 and the subsequent ones apply.
Excellent.
Yeah.
And perhaps just on this point...
No, I just want to be clear because it may matter to what is said, Mr. Poole. You say that the practice in St. Lucia is certainly not to put in the defence statement generally,
yes,
as part of the Crown's case. In other words, you don't in opening. But would you even be entitled to, without first getting a ruling to that effect?
No, in my submission on a proper interpretation of legislation as it sounds, say no.
Yeah. All right.
And perhaps, I don't know if it would assist the board, but just the point made by my learned friend, Mr. George, perhaps the sort of local considerations point. Obviously, I see the point that if there is a lack of representation generally of accused, the requirement to give a defence statement could give the risk self-incrimination. Well, in my submission, the answer to that is perhaps fourfold. I say first, it's really a question of timing, which is a point that's made in the respondent's case, namely that if all that is being said in the defence statement is what the accused intends to say at trial, then there's no unfairness in requiring advance notice of that. Second, refer to all of the safeguards that are in place, particularly the safeguard in section 912(2), but also the judicial safeguards and the exercise of the judge's discretion and control of the trial. Third, it would not have been a point in my submission that would have escaped the local court of appeal, who...
But it doesn't appear to have been argued in front of them.
I accept that.
Well, I mean, it's a point which goes both ways, because they, above all, are a better place than we.
that's really the point that I was making, without it even being expressly argued, the Court of Appeal, in my submission, would have well in mind the local conditions. And a point that was being argued was that this was an infringement. The requirement to provide a defence statement was an infringement against the privilege of self-incrimination. Yeah. So they would have had well in mind those arguments. And then fourthly and finally, it doesn't, in this point, my Lord Hughes made, it doesn't strictly arise in this case because we know that the appellant was represented throughout and he was given a warning at the second case management conference, expressly warning him about the potential for adverse inferences from a failure to provide a defence statement.
Right. Now, if you're right about what 909 requires and permits,
my Lord,
by way of non-committal response in the absence of a positive case, in your submission, does that impact on any form of right to silence or right against self-incrimination which is preserved by the Constitution?
My Lord, we say no. We say, well, firstly, there's nothing inherently unfair or unconstitutional about being required to give an indication of an issue in advance of trial that is going to be a material issue at trial. So as of their nature, Section 909 and 912 are not unconstitutional. Much depends, and this is the point that Lord Mustill was making in Murray and the DPP in the passage that the board was taken to by my learned friend. Much depends on the nature of the issue, the weight of the evidence that the prosecution adduce on it, the extent to which the appellant should, in the nature of things, be able to give his own account. And then one cannot, in my submission, ignore the role of that the trial judge plays, because ultimately it's he or she that controls the cross-examination, comment, adverse inference, and directions. So
what is the correct analysis of the precondition in Section 912(2) that you shan't be convicted of an offence solely on an inference drawn under subsection 1?
Well,
in this context, i.e., we were shown some authority which it was suggested was contradictory.
Well, in my submission, you get some assistance in answering that question by looking at the standard direction that is normally given, and one finds an example of that in another case that was considering, in England and Wales, considering the identical provisions here to those in the criminal code. And it's the case of Bryan, Queen and Bryan, which is under tab 32, which is page 686. And in Bryan, if I can pick up the judgment of Lord Justice Latham, at paragraph 22, bottom of page 690, not relevant directly to Lord Mance's question, but there he's talking about the right to silence and the fact it is...
yes, right, so this is helpful. This compares the present situation with Section 34 and 5.
And then over the page, Lord Justice Latham refers to Section 5, which is the equivalent of Section 909, makes no inroads into that right. And then dealing at 24, and this is the...
yes, this is the same point about you prove it, yes.
And at 25, talking here about the safeguards that are in place, and saying as far as the direction that the judge should give to the jury, similar considerations apply. If the judge considers it appropriate to leave the question to of whether or not failure to serve may indicate guilt, he'll be constrained first by Section 11.5. Now, 11.5 is the equivalent of 912(2), and must accordingly direct the jury to the effect. And then there's a reference to Tibbs, which you lordships have seen. And then you have there the Judicial Board standard direction, certainly in April 2003, And perhaps just the last sentence, if you're sure that he failed to give a defence statement at all, you may draw such conclusions as you think are proper in deciding whether he was guilty of the offence, although you should not convict him wholly or mainly on the strength of any such conclusions. So that, in my submission, is how a judge would appropriately direct, by specific reference there to section 11.5 or in...
Have you looked at the current bench book? I suspect it still says the same, but I honestly can't remember.
By the way, I can't tell you whether it's identical, but...
It derives from Argent, doesn't it?
Yes.
Yeah.
Yes.
And you've got also 26. No other, draw the inference only if sure there's no other reasonable explanation than that the explanation for the contrast is guilt.
Yes.
Yeah.
Yes, and we do say... Well,
bit like the lies direction.
yes.
I mean, this really counsels that you should, as a judge, investigate at trial whether the defendant was, as Sir Ronald was suggesting, fully informed about the consequences of not giving a...
Absolutely, and that's why we say in our written case that it is important, on the facts of this case, to acknowledge that a warning was given to this defendant, because a jury is entitled and should be directed to take into account the state of an accused's knowledge of, first of all, the requirement, obviously, but then the consequences of failing to provide a defence statement or saying something in your defence that is inconsistent with the defence statement you've given. They're all relevant considerations for the jury in considering any adverse inference that is to be drawn.
Yes, Tim.
728 as well. Yeah.
I think the up-to-date version is more or less the same. You should not find the defendant guilty only or mainly because you are satisfied. And he has now put forward a significantly different version. It is only one of the matters you can take into account.
Yeah.
Right. So are there any other points you want to make on the areas which we asked about?
My Lord, no, and if I were to make any further points, they would simply be sort of saying what I've said in my written case, which your Lordships have had and read. So unless there's anything I can assist with further.
Well, thank you very much indeed. Yes, Dr. Dorset.
Yes, my Lord. Question was asked of my learned friend as to what exactly, having regard to the criminal code, what arises or what may be found in the defense statement. Referring back to tab 2, my Lord. Tab 2, page 209 of the record, section 909, subsection 2. I draw your Lord's attention to what, in fact, was stated by my learned friend in his written case, page 179 of the record. Page 179 of the record. Para 60.
Para 60, thank you.
And the last sentence, which my learned friend states that a defense statement can contain admissible facts, but it doesn't have to. And what we say is that this is where a real danger arises and a real risk of infringement of the right to silence, particularly in cases where a large proportion of the defendants may in fact be unrepresented, a judge may do his endeavor best to explain. And we can't fault any judge. We're not seeking to fault a judge in the explanation. The question is, having been explained to, a layperson could quite easily, there's a, what do you say, a real risk that admissible facts comes into play. And
some are bound to. I mean, if an alibi notice contains assertions of admissible fact, doesn't it?
yes,
I was at the football.
yes, but we have spoken to the special nature that alibi and special defense.
Yes, quite.
And so, but I just want to make the point that we're dealing here. And this particular case, it's not so much about Mr. Sexius and the particular circumstances, is that there is a vice that we have recognized, and there's a risk that we think ought not to come into force.
Yeah.
And that really is our short point. There's a vice and a risk. Yes. And
Just ask, was that all you wanted to say?
yes, that's basically is my reply, because the question focused on exactly what is to be found or contained in the statement.
Just help me as to one point which isn't directly relevant to what the submissions you'll be making, but as a matter of interest, has your client been in custody the whole of the intermediate period?
If Mr. George could be with us.
No, he's on bail.
He's on bail. Yes, thank you.
As a matter of fact, Millard, although this matter has been pending, he was requested to file a defense statement, nonetheless, which we had to do.
Yes.
So, I mean, well, basically you would... but the trial hasn't gone forward?
No.
It's been held up pending this...
Well, we got to stay on pending this.
After all, if you're right, it may be impossible to try him. Yes. Okay.
Thank you. Well, the board is grateful to counsel on both sides for their very helpful written submissions as well as their helpful oral submissions, and will take time to consider what advice it will humbly tender Her Majesty. Good to see you.